CourtTv.
All right, folks, before we head back to court, let's bring in our guest. Joining us this hour to discuss is Los Angeles-based criminal defense attorney Silva Mergadichian. Silva, great to see you. It's been a long time. Thank you so much for joining me tonight on the show. Always a pleasure to be with you. I want to talk a little bit about the standard here. In order for the defense, you can't pull something out of thin air and say, oh, that person did it. You can't do it. That's just not fair. There's required a substantial nexus in order to claim. And in this case, they're claiming specifically Brian Albert, Colin Albert, or Brian Higgins were the people involved in what happened to John O'Keefe. Talk to me a little bit about this standard of substantial nexus. It can't possibly mean the court wants them to be prosecutors and come up with enough evidence to prove something beyond a reasonable doubt or something in that lane.
Yeah, first of all, Michael, thank you so much. And it has been way too long, my friend.
Yes.
Always watch your show and adore you. But yeah, you know, here's the problem you have, right? You have a very different prosecutor for this second trial. And he really is trying to essentially take away all reasonable doubt. I mean, that's what prosecutors do. Essentially, he lost that first trial by having the hung jury. So he is trying to find a way to get everything excluded. And you're right. There is, you know, it was funny because the defense really threw everything. They threw the pasta on the wall and they wanted to see what would stick in the first trial. And what's interesting is I felt that the prosecution really did not do a good job showing that these defense theories were just garbage. I think the jury just really felt like there was an abundance of reasonable doubt, which is what led to the hang. So look, the prosecutor did a very good job in discussing the fact that the standard is not met. However, I still believe the judge is going to allow it in. I still believe that the defense is going to put together a viable nexus that will actually leave it in the judge's hands to say, look, prosecutor, if you think that this is a loose standard or you don't think the defense can make it, you have ample opportunity to actually discredit everything they're saying. Save it for your examination, save it for your close, save it for your open. Make the defense look like idiots that, look, jury, this is a black and white case and they're trying to muddle it with gray. So, you know, again, the prosecutor is doing his job, trying to exclude everything, making his job easier. But this is a really phenomenal judge. She has made, I really believe her decisions have been based in law, but also based in letting the jury make their decisions on fact, on what evidence come out. And we cannot forget that the jury in that first trial came back with hangs, and there was a reason for it. The defense was able to show, first of all, lack of intent with Karen Reed, and secondly, that something bigger or smaller was afoot here that allowed the jury to get her an out. So I do think the judge is going to allow everything in an abundance of caution.
You know, in interviews, and we did one here at CourtTv with the jurors, they just didn't buy the fact that she had hit him with the car at all. And I don't even think that had anything to do with this third-party culprit. So my question for you is, and you talked about this, that the prosecution can spend time trying to debunk some of these theories, these third-party culprit theories by the defense. But I posit the more important thing that they have to do in this case is really focus on proving, based on the evidence, that John O'Keefe was hit by that SUV.
Exactly. And remember, Michael, too, the dog stuff, right? The injuries to the arm. There was just an open window for a jury who wanted to believe that Karen Reed could not have done this. They gave them a reason, right? And I'll tell you, you know, this Max series that came out on the Karen Reed documentary, you know, I always say, and you've heard me, Michael, say it, if I had $1 for every time I said, don't talk to the media when you have an active criminal case. Look, a lot of people don't want to believe that Karen Reed did this, that he was never hit by the car. And I'll tell you something, you know, I'm a believer that there was absolutely no intent here. There was no motive on her part. At most, this is a tragic accident. So, you know, again, it's going to be left in the jury's hands.
Yeah, and again, I want to get into this whole idea of whether all those interviews and things that she's done ultimately will end up hurting her, because I think they certainly will. But right now, I want to take folks back inside the courtroom where the Commonwealth is now talking about the police investigation and the defense's attempt to introduce another possible suspect known as the third-party culprit defense. Let's listen in.
Is a suggestion that Mr. Higgins was going to kill both of them?
or he was going to kill one of them, so the other one he would then set up for murder so that he wouldn't be able to see her anyways. The absurdity of the relationship between the claim and reality is so great that it will just run rampant through this trial. It'll be unrelated, speculative, shotgun approach to claims that the witness will spend their time trying to explain and defend. It will distract the jury, and it will serve the purpose, which the case law says it shouldn't, of taking attention off the facts at issue for the case we're here from. And that attempt to divert anybody but the defendant is the attempt here. That's why we have three, we don't know who, but three potential third-party culprit evidences with absolutely fragile evidence. It's feeble. They, as their support, what they offer is they believe Mr. Higgins lied because he went to the Canton Police Department to do administrative work, and I think the evidence is clear that he had cars that he parked there as part of his job that he needed to clean off, so they are parsing words in an attempt to create a basis that doesn't exist. That there are calls between Mr. Albert and Mr. Higgins later that night. So what? They have no evidence that either of them spoke to each other. They have no evidence of conversations. They have no evidence of a conspiracy. They have no evidence of a cover-up. They have no evidence of a weapon. What we know is John O'Keefe never went in the home. And so to try to create this image based on obscure facts is not the substance that's required under third-party culprit. I know third-party culprit is a time-honored tradition and is a broad latitude, but it's not endless. It can't prejudice the Commonwealth. It can't distract the jury. It can't be based on fiction. It has to be based on an identifiable theory. The cases that have allowed third-party culprit that have been reported have actual people who could be a third-party culprit, who actually have relationships to the scene or the crime or the deceased. In this case, an attempt to call Mr. Higgins a liar or create fictions about what they think he could have been doing or guessing what they want him to do is not evidence. 9 people testified John never came into the house. 9 people. There is no overwhelming evidence or any evidence he went into the house. There is no evidence of motive on any of these 3 people they identified. They've had, before the last trial, the entire trial, and was aptly pointed out, no request for a third-party culprit instruction. And then they had since then to make an actual proffer that people actually have the motive, opportunity, and intent to do this. That there's actual evidence that there's this alternative theory, and they failed to do it. To have the defense go through a trial, distract the jury, attack the reputation and character of the witnesses, and then not even ask for an instruction at the end. It evidences the fact that there is no basis for a third-party culprit. Now, separately, third-party culprit is part of Bowden. Even if the defense at the end does not warrant an instruction, I recognize that challenging the police investigation is virtually an entitlement of a defense. How they do it and the extent they can do it is a different story. Simply because they have an attack on the police investigation does not let them use third parties as part of that. And so the standard, Silva Santiago, is very clear, it's cited by almost every case, is that there has to be something the police didn't do at the time that they knew about and should have done. So at the time the police did their investigation as being criticized, they would have had to have known about a potential third-party culprit or third-party culprit evidence and didn't pursue it. And that's where the defense argument utterly fails here. Because at the time the police were doing this investigation, what they knew is that John O'Keefe was on the front lawn of 34th Avenue near the street. They knew that he was dying or is dead. And a number of witnesses knew that Ms. Reed was saying, I hit him, I hit him, I hit him. A number of witnesses. Shortly thereafter, what the police knew is that Miss Reed's taillight was cracked. And shortly after, what they learned and knew after they got her car is that part of her taillight was missing. So at that time when they were doing their investigation, there was no claim of dog bites. That came months and months later. They went to 34 Fairview and they spoke to the owner, according to witness testimony. And everything seemed appropriate. Concerned, confused, no blood, no scratch.
All right, we're going to stop it right there. When we come back, we're going to bring you the defense's response to the Commonwealth, and they say that there's ample evidence showing that someone else caused John O'Keefe's death. Defense attorney David Yannetti takes the podium next to argue why the third-party culprit defense is highly applicable in this case. Stick around. Keep it here on CourtTv.
Hi.
Welcome back to CourtTv Live. I'm Michael Ayala. Now back to Massachusetts, where accused murderer Karen Reed was back in court today ahead of her retrial starting up next week. Now, Reed is accused of running over her boyfriend, Boston police officer John O'Keefe, and then leaving him to die in the snow. Well, today, attorneys on both sides addressed several motions, including that old pesky third-party culprit defense. Let's get you back into the courtroom now. The defense is getting their turn to argue.
John O'Keefe's death. Regarding the first issue, which Mr. Brennan spent a lot of this argument on, there is ample evidence tending to show that somebody else caused John O'Keefe's death. In our opposition, we have cataloged the evidence against each of the potential third-party culprits that we named the last time we were in court. Each one of them had a motive and an opportunity to harm John O'Keefe. The investigators in this case had evidence that pointed to Brian Albert. Brian Albert is a violent man. He was not only a boxer who punched people in the ring, he was also a violent drunk who sucker punched other police officers. Those police officers are on our witness list. He's been investigated by the Boston Police Internal Affairs for having done so. There are many police officers listening to this argument right now who are nodding their heads. We've heard from many of them. It's undisputed that Brian Albert was present at the scene of the crime. It was his house. He claims to have been sleeping merely several feet away from where John O'Keefe's lifeless body was later found. There is evidence that John O'Keefe entered Brian Albert's house. The Commonwealth may not agree with that interpretation of the evidence, but it exists. It's a live issue at trial. At the time John O'Keefe entered that house, an intoxicated Brian Albert was inside. He had been drinking day and night for hours at a time, and he was liquored up. He testified to that. He was at the hillside when he had his first drink in the afternoon, and he testified under oath he was drinking consistently the entire rest of the day and night. The Commonwealth says that every single person didn't see him in the house. Those same witnesses that the Commonwealth points to, every single one of them also did not see him on the front yard, where Mr. Brennan claims that he was at the relevant time period. That day and night, Brian Albert was attached at the hip to his close friend, Brian Higgins. This was the night that after having carried on a flirtation with Ms. Reed while she was dating Mr. O'Keefe, Brian Higgins was confronted with Ms. Reed and Mr. O'Keefe together. In the words of one eyewitness, Ms. Reed and Mr. O'Keefe appeared to be lovey-dovey that night. Higgins had expressed his interest, but it went nowhere. And it went nowhere because prior to January 28th of 2022, Ms. Reed had rebuffed him, essentially ghosted him. She stopped returning his messages. Brian Higgins was liquored up that night as well. They're both very large men. The court saw them on the video. Friends who drank the entire day and night, and they were waiting in the house for Mr. O'Keefe to arrive. Mr. O'Keefe ended up dead because he went to Brian Albert's house. After Brian Higgins left, Brian Albert maintained contact with him. At 2:22 in the morning, the two of them were exchanging phone calls to check in with each other just a couple of hours after Mr. O'Keefe was mortally attacked. Mr. O'Keefe had dog bites and or scratches on his arm consistent with a dog or an animal attack. Brian Albert had a large German Shepherd who had attacked and injured somebody in the past. It all fits. The Commonwealth utterly failed to investigate Brian Albert as a potential suspect, and I'm sure the court remembers the words in a text message of now ex-trooper Michael Proctor, the lead investigator who's now been fired as a result, in part, of being biased in this investigation. I would point out also that when Mr. O'Keefe was in the house, both Brian Albert and Brian Higgins were unaccounted for, according to the testimony. With regard to Michael Proctor's words, he was asked specifically if the homeowner would catch any grief for having a deceased person on his front yard, and Michael Proctor said, nope, the homeowner is a Boston cop too. The message was clear. If you're a suspect, you get fully investigated unless you're on the right side of the blue wall. If you're a police officer, you get a pass. Now, in addition to the 2:22 a.m. phone calls with Higgins, there's other consciousness of guilt evidence implicating Brian Albert, and I would note this is not something that Mr. Brennan addressed in his argument. He didn't talk about the consciousness of guilt evidence. Despite a massive police presence on his front yard, just feet from his bedroom, Brian Albert never came out to speak with investigators. And it's worth noting, it's worth stressing, that Brian Albert was a first responder. He chose to ignore his duty to help somebody in need and instead stayed in his bedroom. And Brian Albert's dog, the family dog, a member of the family for 7 years, Brian Albert got rid of the dog, shipped it to another state, only after it was made known in court that the defense was alleging that the dog had been involved in the attack on John O'Keefe. We showed photos of John O'Keefe's arm in a public hearing where it was clear to any unbiased observer that Mr. O'Keefe suffered those particular wounds from a dog or animal attack. Brian Albert responds to that allegation by essentially divorcing his family from their beloved dog, whom they had had for 7 years and certainly considered to be a member of the family. In the aftermath of John O'Keefe's death, Brian Albert went so far as to send that family member to another state. That's enough evidence to point to Brian Albert.
All right, we'll step aside here, folks. We'll take a break. When we come back, we're going to continue to hear the defense argue about why they believe someone else is responsible for the injuries and the death of John O'Keefe rather than Karen Reed. Keep it here on CourtTv, your front row seat to justice.
Tonight on Closing Arguments, the fast-approaching retrial of Karen Reed. We're unpacking today's big hearing as she prepares to face a jury once again.
Closing Arguments, tonight at 8/7 Central, only on CourtTv.
The jury was sequestered for 9 months.
These people were too beat down to even try to fight for their own conviction.
Trial and Error. Why did O.J. win? Season finale Sunday night, 8 Eastern and Pacific, only on CourtTv.
Welcome back to CourtTv Live. I'm Michael Ayala. We're following the final pre-trial hearing for Karen Reed ahead of her murder retrial set to begin next week with jury selection, and that could take a week or two. Well, now her attorney is arguing that someone else was responsible for her boyfriend John O'Keefe's death, not her. So let's go back inside that courtroom.
Party culprit in this case. It's evidence that he had the motive, intent, and opportunity to hurt John O'Keefe. Brian Higgins is another potential third-party culprit. Like Brian Albert, Brian Higgins was present at the scene of the crime. He was there at the relevant time, in the house, again, unaccounted for, at the same time John O'Keefe would have been there. Brian Albert had cause to back up his friend, but it was Higgins himself who was the one who had been flirting with Ms. Reed in the weeks leading up to January 29th. He testified that she kissed him goodbye after they had watched an NFL playoff game at a get-together not long before January 29th. He testified that she had visited him at his apartment after that, but he acknowledged that their text exchange and all contact between them ended, and Ms. Reed was the one to end the contact. She stopped responding to him. She no longer gave him any attention. So we come to January 28th. Brian Higgins sees Ms. Reed in person, but she's not alone. She's instead with Mr. O'Keefe. Ms. Reed and Mr. O'Keefe are affectionate with each other that night, and Higgins is there to see it, as is Brian Albert. There's evidence that Mr. Higgins wants Mr. O'Keefe to come to the Albert's house that night. In fact, he appears fixated on making sure that Mr. O'Keefe went there. In the waterfall video, Your Honor, you will see that Higgins motions to Mr. O'Keefe when they're leaving. And Higgins even texts him directly after that to make sure that he was coming. Then Higgins goes to the Albert home. John O'Keefe goes inside. Higgins is there waiting for him, with both the motive and now the opportunity to hurt John O'Keefe. Like Brian Albert, there's evidence of his consciousness of guilt as well. After a long day of driving and drinking, Higgins leaves Brian Albert's residence, does not go home. Instead, he goes to the Canton Police in the early morning hours. He initially claims he went there to do administrative work. He changed that testimony at trial to him going there to move a vehicle. But he's always maintained, including in the first trial, that he never called anyone. We've learned since that trial that Higgins is at the station on video making a phone call. So I suppose the question is, why did he lie about that? The jury in this trial should be entitled to consider the answer to that question. And of course, the police never investigated who he was calling or what he said or who was calling him. Then he goes home and he still stays up. And at 2:22 in the morning, he's speaking by phone with Brian Albert. And he claims that they didn't, but the phone records don't lie. And this notion that these two men are somehow able to butt dial and butt answer each other is just ridiculous. And there's more consciousness of guilt evidence with regard to Higgins. When he realizes that investigators might be interested in the contents of his phone to see what evidence might be on it, he demonstrates consciousness of guilt by getting rid of his SIM card and the phone itself. And how he got rid of it was extraordinary and demonstrates just how badly he wanted to keep that information out of the hands of investigators. He admitted to breaking the SIM card into and making a special trip to a military base to put this tiny object, the size of about a thumbnail, into a large dumpster. It wasn't enough to throw it in a waste paper basket or a trash bin outside the local Dunkin' Donuts. Instead, he went through security at a military base and secretly tossed this tiny broken SIM card into a dumpster. He made sure that investigators would never know what's on his phone, and he admitted to that at the first trial. And of course, the investigators in this case, including the lead investigator, former trooper Michael Proctor, never showed any interest in Higgins' phone. Higgins nonetheless accomplished his goal of keeping the contents of the phone out of the hands of the defense in this case. That's powerful evidence of motive, intent, opportunity, and consciousness of guilt of Brian Higgins. As Mr. Brennan acknowledges, all doubt should be resolved in favor of the admission of third-party culprit evidence, linking him to the harm caused to John O'Keefe. And finally, Colin Albert is a potential suspect. He had been in a feud with John O'Keefe. He'd thrown beer cans in his bushes, told him to F off. We have a good faith basis to claim that. This is the same Colin Albert who testified under oath he had never been in a fight in his life, yet there are videos of him clearly desperate to beat up others. The same Colin Albert who had scraped up knuckles just a few weeks after John O'Keefe's death. Those knuckles looked consistent with an attack on somebody. The photographs that Mr. Brennan references that were allegedly before that photo had no metadata. We can't confirm when those were taken. Mr. Brennan wants us to just accept the testimony that they were taken before the scraped up knuckles photo. We don't buy it. We don't think a jury will buy it. When John O'Keefe was found, he had two black eyes looking like he had been punched in the face. Colin Albert was at his uncle's house with both his uncle and Brian Higgins, disliking Mr. O'Keefe for a different reason, but disliking him nonetheless. And it's suspicious that Colin Albert's name was purposefully omitted out of the police reports. There was no indication in any police report provided to the defense in the first few months of this investigation that Colin Albert was anywhere close to 34 Fairview, his uncle's house, on January 29th. In fact, there's no indication in those police reports that Colin Albert even existed. Initially, we didn't even know who he was. But we found out when we sent a letter to Mr. Lally, while the case was still pending before a grand jury, notifying the Commonwealth that Colin Albert should be called as a witness before the grand jury. It was only after we sent that letter, notifying the prosecution that we were on to Colin Albert, that testimony was elicited that Colin Albert was indeed at 34 Fairview that night. The defense caused this to be revealed, not any investigator of this case. And there's obviously an inference that his name was kept out of the police reports to protect him. The same way Brian Albert is the only person listed in the initial report whose first name is not even spelled out. He's just listed as B. Albert with an incorrect address.
All right, still with us, Los Angeles-based criminal defense attorney Silva Mergadichian. And Silva, you know, David Yannetti laying out things we heard a lot of in that first trial. Quite frankly, sounded fishy then, sounds fishy now. Still things that are questions that I feel create enough of a nexus for this jury to make decisions. Things like whether this happened or something happened in the house, outside the house. There are questions there. Whether these phone calls were butt dials or something more sinister, part of a cover-up. Whether these are bite marks or whether they're not. I mean, these are questions that I think it's fair to say should go to this jury.
Absolutely, Michael. And here's the thing. The jury is smart enough to put it together. And you know what's funny is we're listening to this, and it really does sound like very strong closing arguments by both parties. Let the jury decide. You know, again, they laid out the evidence the defense did in the first trial that really made you question a lot of things. Incredibly pro-prosecution, there were holes here. There were really inappropriate text messages. There were a lot of gaps and deleted messages. And oh, I got rid of my phone because I had to get a new phone, but then nothing was saved on that phone. There were a lot of questions. Why not let the jury hear it, let them decide? I do think there's a nexus here. I think the strongest argument is the blue wall argument, right? Officers really did narrow their focus on Karen Reed from the very first second of this investigation. As defense attorneys, that's why we have our investigators go out and further investigate what's going on, because we see this all the time. They'll focus on one suspect and one suspect only. The defense has the right to show there were other possible motives here. Again, it's a little sketchy, but I do think it should go to the jury just like it did in the first trial, and let the DA do their job. If you think it's completely stupid, then argue it. But the jury should hear it, should see it, because there are too many unanswered questions.
Yeah, and again, remember, under this standard, substantial nexus, all the inferences go with the defense, and they should be given a wide berth to make these arguments. Again, it's the liberty of the defendant at stake. I want to go back to that issue that we talked about the last time we spoke, and this is regarding the comments that Karen Reed continues to make. Now, in theory, the idea is you want to call some public support, which she has a lot of right now, but she continues to do a lot of these interviews. But those can hurt her. We saw that in some of the arguments in this case, where they talked about some of the things that she said on an interview opened up the possibility that the Commonwealth could have access to text messages between her and her lawyer. I think she needs to shut it down. Talk to me about that.
Oh, Michael, I was so shocked. I mean, it opened up the floodgates to the prosecutor asking for actual communication between Karen Reed and her attorneys. Anytime you go to the media, it's a Pandora's box. You don't know what's going to happen. I don't understand what the decision was and why. You have her attorneys who are also openly talking about defenses, openly talking about evidence. What's interesting is you already have public support. Why do you need a docuseries right before a retrial? I think it really does open the door to prejudices. And I'm shocked by it, but maybe they know something we don't, Michael, because I've never seen it like this.
I agree. It raises serious questions. But again, these are seasoned attorneys, so I guess I'm going to give them the benefit of the doubt under these circumstances. All right, Silva, thank you so much for joining us tonight. Always a real pleasure to have you on the show. Truly appreciate you. Folks, we want to remind viewers that